So I'm here to talk about the exciting world of powers of attorney and guardianship, which I often tell people that your decisions will be hard, but fortunately your options are few. And that's, I sometimes feel like when I do presentations like this, I oversimplify, but I don't really think I do. I think it is, quite frankly, this simple. Just a little quick background. In 2010, I left the practice of law after 20 years of doing it, elder law exclusively, and we moved to China. We were Christian missionaries there permanently the rest of our lives. Then our oldest son here in the States died in a car accident, and we, with one phone call, moved back to raise his children. His wife didn't know it until the day after the funeral that she was pregnant with the fourth. And so we moved back from doing that. So we've been raising, we have 10 grandkids and 2 great-grandkids, but anyway, doing a lot with that. So that sandwich generation, now my mother-in-law is almost 92. Most of my wife's days are filled with, repeatedly reminding her that she'll be there at a certain time to pick her up for that day's doctor's appointment. And then back in April, it was a rough month. There's 2 things I have a hard time talking about. One is my wife. But anyway, ends up a lot of medical issues, ICU for a couple weeks, all that. Well, it culminated with one of the reasons is we didn't know it, but she has leukemia. And so she's now struggling with the chemo and all that. So it's like, wait a minute, I'm supposed to be sandwiched. Not supposed to be in the middle too. So kind of getting it from all ends. So for all those years, I talked to people that were in this position, but boy, it's a lot different when you're in it. And you're making those decisions for your own loved ones. So anyway, now I get to apply all the stuff I've known for years. So let's see here, that one's not the right one. There we go. All right, in case I am incapacitated, there's 2 alternatives, and really it's not any different, it's not this hard. It's like even when finding nursing homes, people are always like doing this research and that research, and they're trying to turn over this rock and that rock. Well, there's ways of discovering, nope, here's everything for you. You don't have to keep talking to people, and what about this, what about that? Well, if somebody is declining in their capacity, there are only 2 options. One of them is in advance, you've done durable powers of attorney, and the second option is a guardianship through the probate court. That's it. So if I can no longer make decisions for myself, if I hadn't done a durable power of attorney in advance, which that's not necessarily going to be the answer to everything, but that is the better option to at least try out. Now, I turned this stuff in some time ago, and I looked at it last night, so I'm going to try to remember what I wrote down. Durable powers of attorney, that's what you always want to do if you have the option to. So when it works is when it's done. I mean, I can't tell you how many times people walk into my office and they've been talking about having their estate plan, which typically includes durable powers of attorney, done, but they haven't done them yet. So you do have to do them. Then there also needs to be, when they're compliant, one of the things that you always want to try is to have the powers of attorney, but the issue with the power of attorney is it does not give you authority over a person. So if somebody still wants to go write checks on their bank account, if they still want to sign contracts, if they still want to drive, if they want to do all that stuff, then if they want to go to another lawyer and sign another power of attorney for somebody else or to remove you, they can do that. Their rights to do that have not been taken away. So when you do it, when they're going to be compliant, and when it's accepted, that's kind of a big one. Now, there's 2 different powers of attorneys that I do. I don't think mixing them together is a good idea. I do one for healthcare, which that one's pretty easily accepted. Most healthcare professionals will accept anything they can rely on. And then the other one, though, is what's called a general power of attorney, which I typically in the office call it a financial power of attorney. And that basically deals with everything other than the body. So even if it's arguing with the health insurance company about not paying a bill, or suing somebody, or your utility companies. Just try for the utilities to be in my name and for my wife to do something with them. That's when she usually says, hey, Rusty, would you tell this lady it's all right to talk to me? Well, that's when I can do it, but if I can't, that power of attorney, it's pretty important. But here's the thing, no power of attorney has to be accepted. There's nothing in the law that requires, just because you have a general or financial power of attorney, that when you walk into the bank, that the bank has to accept it. So that's kind of a big deal, because we have a lot of people that walk into our office and they've tried it. They've done it on the internet, or they had one really old or whatever. But for whatever reason, the bank or the insurance company, whoever it is, they don't like it. And you only have one option. If the person can't sign one they do like, the only other option is the guardianship in the probate court. So we try to avoid it. So durable power of attorneys are great when you do them, when the person is compliant, and when the places you want to use them at accept them. So what happens is, oftentimes people, and I'm kind of wondering, so I was kind of surprised. I would have thought, man, this would have been a better attended area, and I'm wondering if one of the reasons, or breakout, whatever, I'm thinking if one of the reasons is because I will hear from people all the time, oh, we've already done a power of attorney. Well, typically, what they typically are talking about on that is the one that covers health care, because those are readily available. If any of y'all remember Nancy Cruzan, that case, it went up to the U.S. Supreme Court. It was a Missouri case, and the attorney that represented the family, it was a Missouri case, and he's a Kansas City attorney, and he started the Center for Practical Bioethics, and they have a 2-page power of attorney. Well, 1 page is power of attorney, the other side's the living will healthcare directive. But anyway, the hospitals hand them out like chiclets, and hey, whatever you got, I don't ever redo healthcare power of attorneys because they will work. But the general power of attorney is a much different thing. So usually when people say, oh, don't worry, we already have power of attorney, a lot of times they're talking about just the healthcare, or they have done them. So if they have done them, I just want to evaluate them real quick, because quite frankly, now's the time to look at them, because you don't want to find out maybe there's something you could have avoided down the road when it's too late to do them. So the first thing I always look at is size. There's kind of a fine line here. If you walk in with a 2 or 3 page power of attorney, the chances are the words that the bank is looking for aren't going to be in that power of attorney. Because it's kind of like when people go to church on Sundays, they just repeat what they think they heard the pastor say. Well, that person at the front desk at the bank, they're just repeating what they think they heard somebody say in training one day. They don't know the statutes, they don't know the law, and so they think they have to see certain words. Well, so the odds are the bigger it is, the words are going to be there. Now, there is a fine line. I was looking over here. It's like, wait, nobody's over here. There's a fine line, though, on too many words. It becomes cumbersome and not very useful then. I've had people walk in with their power of attorneys that are 40 pages long. I don't even want to read that. So who is a bank or an insurance company going to? And it gets confusing. So, if it's 7 or 8 pages, more than likely you're going to be good. Ours are usually 14 to 19, but we really customize them for people. But that's just a good general indicator. The second thing I look for is it immediately effective? Because it used to be back earlier in my career, you only saw these power of attorneys that are called springing power of attorneys. That means they spring into effect upon an event. Does anybody here know what that event typically is described as? A doctor saying that you're incapacitated, in their opinion. So what that means, if that power of attorney says, and it was most common back 30 years ago, that you would see, hey, when 2 doctors say that mom can't make the decisions, then this power of attorney will start. Well, if you're at the bank and you hand them the power of attorney, are they going to take your word for it? No, they want to see the 2 letters. Anybody here tried to get things like that from a doctor's office lately? especially two of them, that ain't going to happen. And it ain't going to happen today. You know, you're going to be dealing with that for a while, but the problem is you need to take care of business today. So I really like them to be immediately effective. One of the things I always talk about, when people get nervous because of that, I'll say, hey, look, I can do the best power of attorney in the world, but if you got the wrong person nominated, they're going to do the wrong thing. Or I could do a real crummy power of attorney, and if you have the right person, they're going to get it done. My job is to make their life easier. And so we're pretty expansive, but the immediately effective is one of those aspects. I kind of think that, well, if that makes you nervous, making it immediately effective, maybe we ought to talk more about who are you nominating? Does that make you nervous that that person has immediate authority? So I like to look at size. Yeah, as long as it's more than 6 or 7 pages, then you're probably going to be okay. I wouldn't suggest probably going through too much expense or trouble to redo them. Is it immediately effective? That's a big deal. And then for this is a statute. Now y'all may, everybody, well, not everybody, but I hear this a lot. People will come in and say, oh no, I can do everything for Dad. Look, the power of attorney says that I can do any and everything that he can do. I mean, it's, all of them say it, but this particular statute says, hey, sure, that's true, except here's 12 things that you cannot do unless they're specifically authorized. Now, some of them I don't really utilize too much, like the ability to authorize an autopsy. That's one of the things that lives on after somebody dies in their power of attorney. The authority in the power of attorney terminates when a person dies, but the ability to authorize an autopsy is one of the ones that's accepted out of that termination that you can authorize. But the reason why I find that statute to be important is because if you're going to do any kind of asset protection or estate planning down the road, we use a lot of those things. For example, the ability to change a beneficiary, the ability to deal with trusts, the ability to make gifts. We use those things a lot in protecting assets, especially the community spouse. So to me, it's pretty important that it's in there. So anyway, for powers of attorney, if you come in and say, hey, we have them, and I pull it and I'm looking at it, those are just my 3 cursory things I'm going to look at. So if you pass those things, often powers of attorney will specifically reference that statute, which that's a positive. So if you cannot get a power of attorney signed because somebody simply does not have the capacity, which, by the way, the only capacity that's needed, you all probably have realized by now that capacity is a very gray scale. Right? There's not a light switch. I was sued years ago for doing an estate plan for somebody who was diagnosed with dementia, living in a nursing home. There was 3 things, but 91 years old. And so I got sued for intentional interference with an inheritance. I kind of found out that people get upset when you disinherit them of $1 million. I didn't know that. But like y'all, I get to learn by experience. So anyway, so I got sued, and I think what these attorneys thought was that diagnosis of dementia was like a light switch, that she couldn't sign anything. Well, testamentary capacity, now that may be true if it was to like purchase a business or to build a house. But testamentary capacity is the lowest level of legal capacity there is. And there's only 3 requirements. I'm going to see a guy on Monday over at Carmel Hills Nursing Home, and that's the purpose in going. Do we need to do a guardianship, or is he going to be able to sign a power of attorney? And there's 3 things I'm going to be talking to him about. One of them is, does he understand who are the natural objects of his bounty? Who's his family? That's what that means. If he has kids, does he know that? Can he name them? If you walk in, so if you're saying, if I'm coming to see your mom, You know, one of my first questions is, well, when you walk in the room, does she call you by name? Because if anybody here is dealing with that older generation, you know, they're pretty good about laying down the smoke. It's like, oh, hey, sweetie, how are you doing? So I'll often ask, when was the last time you heard your mom call you by name? Because that's a question. Now, she'll know you're special to her, but does she really know who you are? I had a guy, I went to this house, I think it was about a year ago, maybe 2 now. But anyway, I was in this house, and I brought all this stuff with me to sign. I'd only ever met with the wife, so which is not uncommon, and because I knew her husband had his struggles, so I was talking with him. And anyway, I just couldn't get this guy to sign. I mean, I'm not going to like high pressure him or anything, but you know, it's like, it's pretty clear this is what he ought to be doing. It's a good thing, but he wouldn't do it. So finally, when I put enough pressure on him, asking him about it, he said, well, I can't sign these things because I have a mistress and I have made her promises, and signing this will, I'll be going against my promise. Well, I'm kind of like, whoa, that's something. So I said, well, what's your mistress's name? And he said, I think he said something like, he had to think for a minute, and he kind of stumbled around like Margaret. And so he's talking, and I said, could her name be Mary? Because Mary's pretty close, right? And he lit up. Yeah, that's her name. I said, is that her sitting across from you? Because you remember with dementia, your long-term memory is good. I think he remembered a much younger woman was his mistress. But that was his wife that was sitting at the table. So anyway, but he did pass one of his other criteria. So number 1, who are the natural objects of your bounty? Number 2, do you generally understand what these documents will do? Well, he understood that, didn't he? I mean, most people don't understand that, but he picked up on it. And then the third criteria is, do you generally know what you have? You don't have to know the balance in the bank or necessarily how many different bank accounts you have, but, you know, yeah, I got money in bank. Yes, I've got Joe, my investment advisor. I got some stuff there. Yeah, I've got this house. This is my house. So that's it. So who by nature should be getting your stuff? That's natural objects of your bounty. Number 2, do you understand generally what signing this stuff will do, what these documents will do? And 3, generally, do you know what you have? So if you can't, if they don't have testamentary capacity, then here you go. You look at guardianships. So what's the procedure for doing a guardianship? It's really not that difficult. First thing you have to do is you have to file a petition. Like that guy I'm going to see on Monday, that's going to be what's difficult. Is it used to be in Jackson County, the county counselor's office would file a petition for guardianship for indigent people or people that didn't have anybody. They stopped doing that, though, before I moved to China. So before 2010, they stopped. So, and over in Kansas, you know, this happens all the time. But you've got to have something to come before the court. That's called a petition. Well, who's going to sign it? Most people don't want to get mixed up in that kind of stuff. One of the reasons why it's probably good not to is because if that person is not found to be incapacitated by the judge, the petitioner is the person that pays all the expenses, including the attorney that the court appointed for that person. So I'll do it. I'll sign the petition, but it's because I go in and I can evaluate the situation, and you know, I'm the one that's taking the risk. What's the likelihood that we're going to not get a guardianship? So anyway, you got to find somebody to file a petition. Then there has to be an attorney appointed. The court will appoint an attorney for that person. And there are rules, laws, that say this is what that court-appointed attorney must do. They've got to talk to them about this. One of the things is that they have a legal right to have a jury trial, which that brings a whole other aspect. One of the reasons we don't do mental health guardianships is because my experience is when somebody has mental health issues, 9 times out of 10, they're going to ask for a jury trial. Now that immediately takes this from probably a $5,000 to $10,000 legal issue to probably a $25,000 to $35,000 issue. And I've never done a jury trial, so it wouldn't be us doing it. In fact, at our law firm, we have a general rule that says if the word objection might be used, we don't do it. So we have litigators that we hire. I'm 60 years old. I've learned life's too short. I don't want to argue. And I don't know how. So number one, you're going to file a petition. Number two, the court is going to appoint an attorney. And number three, you're going to have a hearing. And at that hearing, there's going to be evidence heard. One of the things that the court will be looking for is medical evidence. Typically, we don't have to have the doctors come in. And it doesn't have to necessarily be a doctor, although in Jackson County, it definitely is going to have to be. You have to have MD. I think now they may accept DOs or a doctor of psychiatry. But anyway, they're pretty limited on their experts on what they accept. But usually what will happen is we can get the doctors to do like an affidavit, and we submit that. And it's usually pretty clear by the court-appointed attorney that the best interest of mom is to have a guardian appointed, and so they don't really fight too much. It's not like a big battle. And they just want to make sure that things are being, somebody's rights aren't. This is kind of like somebody I heard one time say, it's kind of like a quasi-criminal case, because in a criminal case, you're having constitutional rights taken from you. Well, that's exactly what you're doing on a guardianship. You can have limited guardianships, which sometimes we'll do those. It can be limited to medical care. It can be limited to placement. And sometimes we negotiate that to make it go easier. Like maybe what we can do is we can do a limited guardianship where mom can retain her rights to own a gun, drive a car, and marry. Well, mom never had a gun. Mom hasn't driven for years, and ain't nobody going to marry her. So, it's like, okay, we'll do a limited guardianship. Because really all we typically care about on that is being able to provide for her, make decisions, and placement. That's usually what we care about. So then if you get a guardianship, let me see, what am I saying here? Okay, are they incapacitated? That's the first question. Here's a statute somewhere. There it is. This is the actual statute that I've kind of edited a little bit. But this is the question that I'll turn to when I'm talking to somebody that's claiming mom or dad is incapacitated. I'll say, are they able to receive, bring in, and evaluate, think about information, or communicate decisions? Are they able to do that? Or are they not, so much so that they cannot manage their essential requirements for food, clothing, shelter, safety, or other care, such that serious injury or illness is likely to occur? So, that's pretty easy. It's like, hey, if you left your mom on her own, can she take her medication? If you left your mom on her own, does she know to call Uber Eats? Or can she make meals? Those are some simple questions. And usually it's no. And so you can at least get a limited guardianship. So yeah, they have limited capacity is what that's called. That's the first question the court's going to look at. The second question the court's going to look at is who should be appointed? Gee, what do you think? I don't know that I've ever had an argument in a case, and I do a lot of these over the last 30 years. I'm not sure I've ever had an argument over, is somebody, do they or do they not have capacity? That's not the argument. This is the argument. Who should be appointed? You got two siblings out there. Well, here's the problem, is that, so my sister and I, which, that's my sister who works with us. So say our dad, who's still alive, let's say he needs a guardian. So I file a petition, I want to be appointed. Well, she has to get notice. She doesn't think I'm going to do a good job. So she files a competing petition. right? So now we have these two people. So I'm going to say, no, she's terrible. She can't do it. She's going to say, I'm terrible. I can't do it. Well, we both may be right. We both may be wrong. Or one of us may be wrong. But here's the thing. The moment we start arguing, the judge is... Anybody here that's raised kids, more than one kid, you know, you're watching those two kids, right? Well, one of them, it's the same argument. You know, you weren't in the room when the vase got broken. So who was the one that did the wrong thing? I played a game with two of my grandkids last night, and it's like there was a mistake made, and we caught it later. And you guys know who did it, right? That third child, his name is not me. I've had kids for 38 years and grandkids. It's like I've heard that phrase too much. So anyway, so I'm the judge sitting up there, and I'm listening to this brother say the sister's so bad. I'm listening to the sister say the brother's so bad. So I make a mistake. If I make a mistake and I appoint the wrong person, who suffers? Dad does. But if I make a mistake and appoint the public administrator, which in Missouri we have, Kansas they don't, which are county employees, well, I know that Dad's going to be taken care of, and the only person that's going to be hurt is me and my sister. Our feelings are going to be hurt. Well, I don't think too many people are worried about that. So the question is who should be appointed, but just so you know, the minute you start arguing, the tendency is going to be that the public administrator or a third party is going to be appointed. Now here, this kind of hearing could be 5 to 10, or to get this thing done, it's 5 to 10,000. But y'all know what I'm talking about, don't you, when I say arguing? Money. You know, because once you start arguing, now I got to put on quite a case that my sister's so bad. And that's going to be all kinds of discovery, and it's going to take length of time, and that just means one thing, more money, which I'm not adverse to that, but you guys might be. I'm not adverse because I'm the one getting it. So then the other is, what is placement? You know, if my sister's appointed, maybe she wants to put my dad in her house, which that's kind of funny, but in any case, you hear that a lot. Or, you know, we live far apart from each other. Where are they going to be in the nursing home, closer to one or the other? You know, that placement thing is an issue. Oh, yeah, and how many people are always happy with the nursing home that somebody's in? So, you know, I go see Dad, and there he's laying in his feces, and he has food all down the front of him, and it doesn't look like he's been in a bed for a while. Well, the placement's horrible, right? So, in any case, those are the questions that the court's going to ask. Are they actually incapacitated? Who should be appointed? And where should they be placed? And following. Okay, what did I put here? I forgot. Oh, yes. I'm trying to convince you why not to do a guardianship if you have a choice. So after you get appointed as the guardian, you got to file an inventory. Every year you have to do a settlement. That's one reason why you don't want to do it, because everything has to be approved by the court. If you want to spend money on Dad, you need to file a motion to get approval for it. Second of all, you got to be bonded. So one thing that happened, this is one thing I learned years ago, this doctor had, he had his trust, and he had a trust, and he had all his estate planning done, and but that attorney believed that the assets didn't have to be in the trust, that you could just put beneficiaries to the trust. So this doctor owned all the assets in his individual name. Well, this guy also had a power of attorney, but he was a son of a gun, and he was not compliant. So even though he had a power of attorney, we had to go do the guardianship. Well, now the problem is, because those assets are in his individual name, those assets are now under the purview of the court. He had $6 million worth of assets. The bond, which the guardian conservator, they have to be bonded. I think that bond, I can't remember, I think it was about $10,000 a year. And that's a real difficult thing to get somebody bonded sometimes. It depends on your credit, your assets, things like that. So anyway, you got to go through the inventory, do settlements, you got to do bonding, and then also you have to ask those permissions. You got to file motions. And if you don't file the motions and getting through your annual settlement, that's quite a pain. So even though you can go to court and represent yourself, you have the constitutional right to do that. If you're the guardian of somebody, you're not representing yourself. You're representing another person or an estate. And if you're not licensed to practice law, then you don't get to do that. So that means you have to have a lawyer with you through this whole process. So if you come and see us, and the person you're getting a guardianship of is 78 years old, they're going to live 12 years, well, you're going to have a relationship with a lawyer, us or somebody else you'll have to, for 12 years. And they don't work for free. So, see, have I convinced you that the power of attorney is the better way to go? If you can do it, you do that. I did not look at the clock, and I have no idea what time it is.
You've got about 15 minutes.
Oh, okay. Thanks.
You're welcome.
I don't know if we'll talk about guardianship, but I'll talk.
10 to 15 minutes, yeah.
So what's the next steps? Like I just said, you find an attorney. Now, to do the power of attorneys, you don't have to find an attorney. Everybody can do their own thing. And that's fine. But one thing we learned in law school is, an attorney, even for an attorney who represents himself as a fool for a client. Because, you know, you get blinded, right? You get too close to the woods, you can't see the forest. And it is kind of funny, because even when I did my estate plan, which we did it just 2 years ago, because what we did is we did one years ago. Of course, you know, when your kids are young, you want to get guardians appointed, right? Well, in the estate plan that we did, that we replaced, my youngest son, who was 25 at the time, wasn't even mentioned. And my other children, the 3 older ones, they all had guardians listed. Well, they were all in their mid-30s. So that's about how long it's been. But it's difficult because, you know, when your kids, we all think we're so smart. I always tell my kids, I wish you would have known me when I was 21. I was so smart, and I've just gotten dumber ever since. Because, you know, we think we are so smart. So they turn 21, 22. You think about, well, I can list them as the guardian or as the power of attorney. And it's like, really? Like when we moved back from China, we realized then we needed to be here. Even though our kids were in their mid-20s at the time, younger to mid-20s, they were not in a position to handle the life issues that we were dealing with. Well, you know, they don't have the assets, they don't have the issues. So that's kind of where we were when we knew we needed to update our estate plan. There are kids where we kind of felt like they were kind of young, but we also didn't want to offend them. Now, my wife is a wonderful woman. I often tell people that don't know her, I'll say, well, hey, go up to, you know, we live in Lee Summit, so pretty much you can go up to anybody, say, hey, do you know Renee Fracassa? And I always say, watch what their face does. That'll tell you about what kind of life I have. It'll light up. She's a wonderful woman. We have a lot of friends. I was the senior adult pastor at a church that has over 6,000 people in it on a Sunday. And we've been there at that church for now just over 20 years. We got a lot of great friends. But do you really want to burden your friends with these issues of your family? That's difficult to do. It's kind of like when I wasn't sure my wife was coming home from the hospital, and I go home to that dark house, very quiet, dark house. I'm not going to bother my kids. And, you know, it's 8 o'clock at night because ICU doesn't let you stay, right? And so I'm not going to call my friends. They got busy lives. Why am I going to dump all this on them? So that nominating a guardian or a power of attorney, which, by the way, the person is called an attorney in fact, or agent. The document's called a power of attorney. But I'm not going to list somebody, you know, it's difficult. So now you see why we were 58 years old and we were doing our estate plan, and that's what I do for a living. It's because it wasn't who gets what, it was who's in charge was the question. So the first thing you want to do is you want to find an attorney, trusted and like-minded. There's not many of us that do elder law out there. There's only probably 4 or 5 in the Kansas City area I would go see. There's probably 20 that say they are, but unfortunately in Missouri and Kansas, we don't have boards of specialization. So I could say tomorrow, hey, I'm just doing divorces. Never done one, but I can say that. So it's kind of the same thing with elder law, which, or probate or estate planning. They can say anything, but you want to make sure they're trusted and like-minded. You could probably guess, I'm a Christian. Maybe that's offensive to people. Maybe we're not going to be like-minded. Maybe we're not going to get along. Well, there's plenty of other options out there. Trusted. Does this person really know? Does their staff really know what they're doing? Because do you really want to talk to the attorney over the time period? No, you don't want to talk to the attorney. Do you know why? It costs a lot more. Yeah. I've got our senior paralegal's been doing this for 32 years. And we bill her out, and I think we haven't changed our rates for about 4 or 5 years. I think it's $160 an hour. I bill out at $355 an hour. And guess what? If you call me and ask me a question, you guys know who I'm going to ask, don't you? I'm going to go to the paralegal because I don't know what's going on. So I always just say, just call Jennifer or one of the other paralegals. But you do want to find somebody that you feel, I mean, you guys, we've all lived long enough. We have a gift of discernment, right? You can usually sit with somebody and know, is this somebody that's good? Of course, we got people on the news all the time that we all trusted to pour our driveway or sell us a car that was in good shape. But, you just got to find somebody you trust and, they think like you. Experience is a big deal. I was telling somebody earlier, I still remember when I was a young lawyer. It's kind of funny. Nobody questions me much anymore. I got questioned a lot when I was like 28, 30 doing this stuff. But I don't get questioned as much anymore. But I remember what it was like practicing law at 30, and I know what it's like at 50 or at 60. I'm not going to go see the 30-year-old. And even me, I'm a much different lawyer now. So experience does matter. A lot of people think that, I always say my biggest competitor is the attorney on the corner. Because most people don't know that there is a difference. So make decisions. What do I have there? Oh, yeah. Who's in charge? That's a big one. Yeah. We do a lot of, because we're kind of specialty estate planning, one of the difficult things we do with guardianships too, or even who's going to be in charge, is the blended family scenario. If I marry somebody, I'm sitting there, I have the way I am about it, it's like I'm all in, 2 are being made 1. So I'm going to appoint that person. But if anybody here's ever been in a step-parent scenario, a second marriage with, the kids, my sister and I, our mom got married. They were married over 20 years. Now, ever since that celebration of life, I have not seen or talked to that guy. No relationship. My dad's had a girlfriend for a while, and even though like 15 years. And the problem is, so what's the likelihood? I know he didn't nominate her because guess who did his estate plan? But if he did, what are the family dynamics? That's tough. You got to think about who's going to be in charge. So that's a difficult thing. So I had somebody in the office the other day, and nowadays the blended families are so prevalent. So these people are, I think they're in their 70s. And anyway, they've been married 4 years. She brought a trailer, a mobile home to the marriage, and she sold, I'm not sure if the trailer was worth $70,000, but $70,000 is what she brought to the marriage. He brought a $500,000 home. He has 39 timeshares. He does that stuff with points, a side hustle type thing. He has a business. It's not $1 million business, but he does well. What else did he have? $500,000 home, 39 timeshares. Oh, he had some annuities, life insurance, and all that stuff. So we're talking about the house. It's $500,000. Of course, they sold the old house because the old wife was in that house, so they bought a new house. And so they're talking about a new house, and they've been married 4 years. And so we're going to do a trust because I asked him, I said, how do you want to divide it up? And he said, well, I think it'd be very fair to do half of the house when we die to her kids and the other half of the house to my kids. Well, I thought, that sounds great. You can't really do a beneficiary deed and get that coordinated. You're really asking for trouble. So we're going to do a trust. And so I said, all right, so when you die, who gets what? Well, he says, well, I think I'm being generous, 50-50. And she says, well, I think it would be more fair if we just divided it equally among the kids. Who do you think had more kids? She did. It's his house. They've been married 4 years, and she has 3 kids and he has 2. Now, sitting there negotiating that, you guys might have already kind of guessed. I always want to be nice, but I've got this personality disorder, I guess, some would say. But it was about 10 minutes after they left, I got a voicemail from him that he had really gotten raked over the coals because of how offended she was by me. And so, but then he calls back too, and he's very much on the same page. I thought he was being fair with 50-50, and then he says, and plus, but here's the funny thing about it, not haha funny. I mean, I deal with death, dementia, and disability. You got to find humor in anything you can. So she has COPD real bad. And I talked to her about that, and she thinks that she's going to get better. You know, we don't want to remove that hope, right? All of us that are dealing with people with dementia and stuff, we don't want to remove hope. So anyway, but then he tells me that even though she's on oxygen, in fact, the meeting had to be cut short because her portable oxygen ran out. She still smokes about a pack a day. So I told him, I said, probably the thing to do, because you're married, you want to stay married, I said, why don't we just do it like she wants to do it? And why would I say that? Because she's probably going to die before him, and he can change the trust however he wants. But in any case, wow, I shouldn't have admitted that. But anyway, but that's all the stuff that you guys, if you guys are caretakers, you have, I'm sure you understand. Of course, if you're the caretaker, you probably don't have any disputes with your siblings because they don't want to do it. That's what happened to you.
So the money's involved.
Oh, yeah, well, come on. If there's money, sure. Yeah. So anyway, so who's in charge? Anybody have any questions? See, I told you, Georgia, it wasn't going to be hard. 10, 15 minutes, no problem.
Question is,
Yes, ma'am.
but we can definitely take questions. I mean, we have like a 5-10 minute wiggle room.
Is your question going to be more than 5 or 10 minutes? Okay.
For a durable financial power of attorney, can you split that to different people? So for example, one relative I trust with my checking account, and one, but I don't trust that relative with the house.
Oh, yeah. Well, here's the issue. You can, what I've done before where I have done something like that, and I just get the people to agree to not, like for that one that has the power of attorney to deal with the house, that they don't show it to the bank. Because then you'll basically end up with nothing. You got to have some kind, because see that person with the checking account, the problem is they think they're trustworthy.
Right.
Yeah. So that's all that blended family kind of family stuff that you have to deal with. You can do it, but I'll tell you, I guess that's the nice thing about doing elder law is I've seen things full circle. It's like, you know, your mom, I do her estate plan. She lives her life. Now you're kind of stepping in and helping her run things. Then she dies and we wind it up. So I've been able to see that. And I think you're asking for some problems there. There's other ways of probably figuring it out. Yeah. The problem is with that also, if you give a power of attorney, nobody reads anymore. So the problem's going to be if you're nominating the one person over here, there's a great chance that improperly everybody's going to accept it, even if you've been specific.
Okay.
Yeah, I'd really kind of talk to somebody about other options.
Okay. Thank you.
Yes, ma'am.
How does power of attorneys work if you didn't go through a lawyer, just went to Office Depot and got their power of attorney form, or you typed up a will yourself and designated what you wanted your assets to go to and had it notarized? Is that still have to go through? How does that work?
You kind of asked two questions there, but that's fine. The first one, the power of attorney, it's kind of like that you don't know what you don't know. And the problem is when you find out your Office Depot power of attorney wasn't any good, the problem is you're going to find that out at a time maybe when you can't redo it. And if it doesn't work, you only have one option you're trying to avoid. No, you can always do that yourself. And, there is a good chance it'll work. There is. So, that's kind of the issue is that, we're not cheap. But I'll just tell you, for a single person to come in to do consultation, power of attorney, get everything on track, we charge a fixed fee of $800, which, if you're paying less than $500, I would question what somebody's doing. So, but the issue is if you got a problem though, and you do a guardianship, our retainer is $5,500. So, yeah, sometimes it's better to just, well, the other thing is too, if you go to an attorney and they've messed it up or they've given you something that's not being accepted, I would hope that they would stand by what they do and they help you get it figured out. Now, the second thing you asked about was the will. First of all, you have 3 ways to avoid probate: joint titling, beneficiary designations, or a living trust. So if I look at your bank account after you die and I look at the statement, and the statement only has your name on it, and there's no beneficiary, according to the bank, that will be a probate asset. You'll either go through probate one of 2 ways, with a will or without a will. The problem is most people think a will avoids probate. No, it just avoids what the law says people get. To do a will, it does not have to be notarized. There's only 3 requirements. It's in writing, signed by the testator, and witnessed by 2 disinterested people. Doesn't have to be notarized, though. So the only problem is when you go to probate it, you'll have to do what's called solemn. I forget what it's called. You got to bring the witnesses in and get these acknowledgments. It's better if you get what's called a self-proven will. That way you can avoid all the formalities later. And a will has to be filed with the court, admitted to the court within 1 year from date of death, or it's no good. In Missouri, you have 1 year. Kansas, you have 6 months. All right.
I have one more question over there, and then I think I'll have to drag you off.
Thank you.
What if you don't have someone to do this for you? Is there some strategy that you would suggest?
Yeah, stay healthy.
Well,
It's
inevitably-
tough. In Missouri, we have, under guardianships, we have public administrators. In Jackson County, John Killian, great guy. We were law school classmates, really a good guy, but you're still under a third party. But you have a safety net. In Kansas, you don't. There are some people out there that act as fiduciaries that will do it, but the problem is they don't typically, I've been doing this 30 years, there's not many, and they don't stick around. I've gone through a number of hearing about them, and the problem is, what questions do we ask? What's their experience? Are they bonded? Those things. I'm going to tell you, it's very difficult. If you don't, I'm acting currently for 4 people as their power of attorney, but that tells you something. They've lived their life in such a way they have no friends or family. And all I've done it for is to keep them out of the guardianship proceedings, because that's just very cumbersome. Now, that's an excellent question, but you thought I was being sarcastic, but no, you don't have many options. Yeah, it's tough. And there's a lot of people out there like that. A lot. They're just getting taken advantage of. That's what it is. All right, Georgia says that's it. All right, thank you guys.
very much, Rusty.
You're welcome.
Great. Okay, so we have about 7 or 8 minutes, so